Who's in the jury boxes?
Ross.
Good afternoon, Doctor.
Afternoon.
You indicated there was organized and disorganized delusion.
Yes.
Where is that in the DSM-5?
Well, as I indicated, delusional disorder is described, actually I happen to know the page, in page 90.
I have.
And it's a very clear description of what I described as a organized delusion.
But nowhere is it listed in that section, correct?
Nowhere is what
Those words, organized and disorganized delusion, those subtypes of delusions aren't listed there, are they?
I don't know if the phrase organized or disorganized is in that text. I'd have to read it. The description of it is certainly consistent with organized and disorganized as I've described it. I'm 100% certain of that.
Where's brain illness in the DSM-5?
Brain illness is not a diagnosis. It's not in the DSM-5.
But you constantly mentioned this was involving brain illness.
Yes, because it's illness of the brain.
You didn't diagnose bipolar, correct?
That's correct.
Why was that?
Because I think that schizoaffective disorder and psychotic disorder, not otherwise specified, are more precise diagnoses. Those diagnoses overlap with bipolar disorder. Bipolar disorder as a single diagnosis is a more specific and particular diagnosis that tends not to include the history of psychosis, which, for example, is treated by Dr. Arthur.
In your report, you did not mention that, correct?
Didn't mention what?
You indicated you was having chronic underlying psychosis.
Yes, and that's what I...
Not schizoaffective or any of those things you just mentioned, correct?
I'm sorry?
Not schizoaffective or the other, I'm sorry, the other...
Psychosis not otherwise specified.
Yes.
Psychosis not otherwise specified is the very specific exact words. Schizoaffective disorder is one of the diagnoses that includes the description that I indicated in my report.
A stimulant can cause a manic episode with someone diagnosed with bipolar disorder?
A stimulant can cause a manic episode in anyone, including somebody diagnosed with bipolar disorder.
And Wellbutrin, the drug, how do I say that correctly? Wellbutrin is known to cause a switch to mania in some bipolar disorder, correct?
Yes.
Okay. Now, a person having a mental illness does not mean that they are insane at the time they commit a crime, correct?
That's correct.
Okay. You indicated that the first time you went to the hospital, they gave him low meds because that's the safe way to do it, cause no harm?
That's one of the reasons, yes.
He was on Halidol and Seroquel?
Yes.
Those are two psychotic medicines. How do you have cause no harm if you're giving low dosages when you give two different psychotic medications?
Okay, just to be absolutely clear, they're antipsychotic medications. They fight psychosis. There are a variety of reasons why two medications might be chosen where it's possible that one would be effective. In particular, Seroquel is a very sedating medication. It tends to slow people down, help them to sleep, sometimes make them too sedated. Haldol is not as sedating, but Haldol has some other problems with side effects. It is likely that they chose those two medications in combination because of the unique benefits of each one balanced together.
You said that you read about an EEG in the prior records for the defendant?
There is reference to an EEG, yes.
You never saw it? The actual EEG?
I did not see the EEG,
Okay.
no.
You saw no records of any other EEGs?
That's correct.
Okay. There were records of CTs and other kinds of brain scans, correct?
Yes.
But the only record, it was a one-time record of that in Dr. Arthur's records, correct?
Of the EEG?
Yes.
That's correct.
Am I wrong? Nothing else?
That's it. Anything further? Okay. Okay. Dr. Mayor, will be excused.
Yes, Your Honor.
Thank you for your testimony.
Thank you.
Sorry, questions?
Oh, sorry.
Guess I'm not going to get any better either. Take your time. Thank you. Juror 1179, and if you need to see it, you were looking at it before, I think. When did the term ADD, attention deficit disorder, start being used? Was the condition called before, what was the condition called before that? If the condition existed before, maybe what was called a hyperactive kid? Question mark.
First part, ADD was disorder in childhood was in the general clinical use in the 80s. As is often the case in medicine, these things appear in the research use earlier than in clinical use. So it was certainly going back to the 1960s in the research literature. And hyperactive kid was absolutely one of the ways that these children were characterized in a respectful but informal way before we had the diagnosis of attention deficit disorder.
Does that answer your question, 1179? Okay, thank you. And then there's another question from 1179. What happens if you don't truly have mental disorders and you're given the medications Mr. Jonchuck is on?
Typically, what occurs in an individual who is receiving medications that they don't need is that their overall condition what you see is a side effects and no other change. Antipsychotics, for example, would not cause a person to be psychotic, but they would cause a person to be sedated. I'm trying to think of if there are any examples of situations where medications can make it look worse when it's not worse. I'm sure there are some. They're rare. I can't think of an example right now.
Does that answer your question, your first one?
Can I just ask a
Yes,
simple
yes.
question? So basically, you just look medicated. Is that fair to say?
For the most part, yes.
Does that answer your question?
Yes.
Okay. The next question from 1179. Do you have to malinger if you are just existing with the effects of multiple medications?
I'm not 100% certain that I understand the question. Can I sort of rephrase it for clarification?
Of course.
Let me describe a hypothetical example that I think would address your question. I used the example of considering malingering in my office setting where I might be evaluating a person for occupational disability. If that person had a claim that they were depressed and apathetic and passive and unable to concentrate, it is possible that they could take significant sedating medications, come to my office, and not do anything else to falsely present themselves. And they might look to me like they were seriously depressed and impaired. In that sense, they wouldn't need to malinger anymore to look impaired, but I might think that they were impaired because they had taken drugs that I didn't know they had taken.
I don't understand.
Okay, sorry.
Okay.
Can I ask a question?
Yes, you can.
I guess it's just, I'm asking, I don't have to malinger or fake a condition if I'm on medication and it's acting the way it's, like you said, you just look sedated. I don't really have to fake anything because I'm just reacting to the medication you gave me.
Well, I guess the thing that I don't quite understand is in this example you're giving, what is it I'm supposed to be thinking the patient is trying to fake? That they're sick or depressed or something like that?
Yeah, whatever their mental disorder is. In this case, you say you can't go years and malinger years, but I don't have to malinger if I'm not faking anything. I'm just on medication and that's it. And I'm just my body and my mental state is just reacting to the medication you gave me. So I don't have to do anything. I just have to take the medication.
Okay.
Does that make sense?
I think so.
Okay.
And I think what you're getting at is do medical professionals, does the hospital staff, do the treating physicians at the hospital have an ability to distinguish the effects of medication which is therapeutically treating an illness, medicating somebody and making them look like they're ill or depressed? Is that, do I understand that better?
Yeah, or they're just existing because of the reactions from the medication.
Yes.
That they gave. I don't have to like act crazy because I'm just normal and I'm taking medication. I'm taking. So I don't have to do anything myself. I'm just my thought patterns and my body's just reacting to what medication you gave me, and I'm just living.
Well, what I would say is a person in that situation, in order to present themselves as medically ill, would still have to exaggerate things, manufacture things, distort things in order to appear ill, that the medication effect and being medicated alone wouldn't present that picture to appropriately attentive, well-qualified medical professionals in a hospital setting where they have a very good opportunity to observe.
Okay, but the medication you're giving me is supposed to be suppressing my mental disorder, correct?
Right. The issue there is that it does suppress it, but none of these medications are curative. None of them make it go away completely. So there's still going to be something there.
But it does suppress it to where it's controllable, and the person's not showing the conditions of their mental disorder?
They're able to function in the hospital environment in spite of the conditions of their mental disorder, but they are still showing it. Maybe not in a way that would be obvious upon casual, non-professional observation, but is certainly apparent in a professional hospital setting.
I guess my point is, if my medications are working, then my doctor would say, oh, you're not acting the way you used to act, so your medications are working, we don't have to adjust them in any way.
Yes, I understand that. And the problem there is, at best, these medications may be 60-70% effective, so they always leave some residual, continuously present symptoms of illness, even when they're working well.
Okay. So if I'm at 30% crazy, can you tell?
In a hospital, yes.
Does that answer your question?
Yes.
Anybody have any future questions? Do seizures make mental illness worse? Number 2023. That's the number.
Yes.
Answer your question? Thank you, ma'am. Any other questions for Dr. Mayer? Follow-up?
Just briefly, Your Honor?
Sure.
In talking about the medications and if you're not mentally ill, how they make you appear, like subdued and all of that. Does the hospital start off, or a treating physician start off with the lower doses that we talked about in order to make observations of that?
Yes. That's part of the reason I hadn't thought of that, but that is part of the reason, another part of the reason that we start with lower doses.
And if as a physician, if you see somebody having their symptoms improve, is that evidence that the medication is working?
Yes.
Thanks.
Any follow-up question? Anybody else have a question based on that answer? Okay. I think you're good to go. Thank you.
Thank you, Your Honor.
May I call your next witness?
Jonchuck, this time to address.
Thank you. Counsel, approach, please. It's not a game, this is the game plan. It's a bad choice of words, it certainly isn't a game. We're gonna do closing arguments 11 o'clock Monday morning. 4 hours of closings, give or take. The state gets the first, the defense gets a rebuttal, the state gets the last. So each side is limited to 2 hours, but the state has to split it up, okay? Does it make sense to everybody? Just so you know what's coming. You'll order your lunch or your midday, whatever it is, early dinner. It'll be waiting for you when you go back to deliberate after the closing arguments, which my guess would be between 3 and 4 o'clock. This is the first time I've ever said this, but I think it's appropriate for this case. If you cannot decide by an hour that you collectively think is reasonable, you can stay all night if you want to, but you don't have to. If you all get tired and say, we're done for tonight, we need to come back tomorrow, then that will happen, and you would come back Tuesday morning to continue your deliberations. And obviously stay away from the press. Okay? Sound like a good plan for everybody?
Yes, ma'am.
Okay, any questions at all? Yes?
When can we request, like, testimonies or information or any of it?
Anytime, you'll go back there, and if you have a question, you write it out, you give it to the deputy, the whole court convenes, you're back there, all the lawyers come back, and a decision is made about whatever question it is. Can it be answered? And if it can, how's the best way to do it? You can ask for a readback of testimony. It requires the court reporter to come into court, whoever was court reporting, well, not necessarily, right? You can read anybody's notes, right, or anybody's...
Yeah, I have the testimony from the first day. Linda, I'll have to get with her to get
Okay.
whoever she did.
But we can get you the testimony, sometimes it takes some time. So what I'll be telling you is, I'll give you a read back, go back and deliberate. When it's ready, we'll tell you. And it's helpful if you can. I mean, if you want to read back, you might want the whole thing. But you might only want a part pertaining to a specific question. So, okay, we want the read back of Fred Jones as to when they saw the bicycle cross the street. Okay? You don't have to, but it's helpful and it speeds it. Any other questions? No? Okay. Have a good weekend. Please don't pay attention to anything about this case. Thank you very much for your service. You all will be very proud of yourselves. Thank you.
All right, leave our stuff now.
Yep.
Okay, are we ready to do the charge conference?
Yes, sir.
Okay, let's do that. Please. Do you have a draft or anything? Of jury instructions?
What?
The charge, you're doing the jury instructions, right? I just presume you were. Not so much.
Ooh, don't put that. I thought you were doing them, Jerry.
No, we didn't know that's how you do it.
I almost, usually for murders, the state does them, but
Okay.
do you want Angie to do them? She'll be so happy.
I don't know if we want to answer that question.
Or we make people in our office unhappy. It's a bad position for us either way.
All right. She says, oh my God, I'm retiring yesterday. So you want first degree murder, second degree murder, manslaughter, any other lessers you're asking for? No? Are you asking for any others? No? And 3.6 is the sanity. And all the stuff that normally comes after both the first, second, and manslaughter, right? It's kind of not that complicated.
We're also asking for felony murder, 7.3.
Okay. What number is that?
7.3.
Okay.
The underlying felony is aggravated child abuse, which is 16.1.
Okay. You can be on TV?
Oh, yay.
Okay.
There may be sections of 3.6 that we don't need.
Okay, 3.6 is the sanity.
3.6A.
6A. He or she had a mental infirmity, disease, or defect because of this condition, consequences, blah, 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 B, okay. All persons have, okay, so obvious gift is applicable. A defendant who believed that morally right. I don't think that's applicable to you? No, okay. So that's unrestrained, that's, you don't want that, do you?
I don't think that,
No, I don't think that.
that's why I was saying those things.
State, do you want, although insanity is a defense, mental or psychiatric condition not constituting or not defenses?
I don't think we need that, Judge.
Okay. Defense, you don't want that, do you?
No.
And judged the same by a court.
That doesn't apply.
Yeah. If you find committed crime was insane, then you should find, okay. Is there a definition of clear and convincing or not?
I haven't proposed.
Yes.
Okay. There is one? Or it's just a proposed instruction?
It says here, clear and convincing evidence is evidence that is precise, explicit, lacking confusion. That's right under the criteria at the very top.
It's in that first paragraph, all persons are presumed sane.
Oh, I see. What's your special one?
Does
I
the
think
court
you
have
probably gave it to me.
brought-
Representation.
Yeah.
Here's one.
This main one.
I reference it in my motion. I would like to, a chance to distinguish, but I do reference it in the motion.
Okay.
I appreciate it.
these from? 411
So those are the civil rules, Judge, that I referenced in the motion. The standard instruction or standard definition is taken from the standard definition used in the civil jury instructions. And those are the only 2 times that clear and convincing is used in the civil standard instructions. And they have both times indicate that if it is used in a situation, those are the 2 times, I'm sorry, that clear and convincing is used in a case that has 2 differing burdens that the jury is going to consider, one burden for one thing and another burden for another. And so both of the, at those opportunities, the civil instruction indicates that if there are differing burdens, they should have that, the extra part in parentheses, the cautionary instruction, that it differs in basically a hierarchy. It describes the hierarchy of the burdens when there's more than one use.
Okay. Do you have any additional argument you would want to make?
I do, Judge. So the obviously I'm aware of the court's holding in Pivo that's a second DCA case. They basically said, oh, the standard instruction is fine. However, it appears from the case that this was an issue that was raised for the first time on appeal. There's nothing to suggest that the defense had requested a specific jury instruction. And so they reference saying, basically they just say, well, it was brought up on appeal, argues that the instruction improperly raises his burden. I do certainly agree that a firm belief without hesitation is synonymous with an abiding conviction that does not waver or vacillate. They indicate the ruling from the second DCA, in this case, it said the Florida Supreme Court addressed this argument when it approved the recommended jury instruction in the Jimmy Rice civil commitment proceedings, and references that. And so it was considered when they reviewed it on the civil side of it. And for the civil Jimmy Rice commitment, the Florida Supreme Court looked at it. However, looking at specifically when this instruction was added to the criminal rules, they specifically state, in doing so, from the Florida Supreme Court, in doing so, we express no opinion on the correctness of these instructions and remind all interested parties that this authorization forecloses neither requesting additional or alternative instructions nor contesting the legal correctness of these instructions. We further caution all interested parties that the comments associated with the instructions reflect only the opinion of the committee, are not necessarily indicative of the views of this court. And so Pivo is specifically referencing that the Florida Supreme Court has accepted the definition as it is regarding civil commitment proceedings. There is nothing, certainly, and there's no indication that requested one ahead of time. The rules taken from the civil standard jury instructions in civil proceedings where somebody's life and liberty is not at issue, the Supreme Court has held if 2 different standards are involved in a case that you have to some kind of way distinguish between the 2 or to tell them. And so, especially in this situation where the language used to describe proof beyond a reasonable doubt and clear and convincing evidence, they're synonymous words. In fact, if anything, clear and convincing actually sounds more firm than the waivers and vacillates and kind of the sing-songy language of the reasonable doubt. Clear and convincing just sounds firm and stern and high. And so the Civil instructions indicate if you're considering both of them, you should. There's nothing to suggest that it was requested in PIVO. There's no indication in PIVO that the Florida Supreme Court, and in fact, we know from the Supreme Court of Florida from the comments and their accepting of the standard jury instruction that they are not expressing any opinion on the correctness. As the law requires, it is an accurate recitation of the law. It does make it more clear for the jurors. And so the federal, I included in my motion, and I'm sorry I gave you my copy, so I can just have one second. The language that I have taken is from the 11th Circuit federal jury instructions, which are Florida insanity statute mirrors the federal insanity statute. So in the federal definition, they said there's an issue about the defendant's insanity. You must consider whether the defendant was not guilty only by reason of insanity. A defendant is insane only if the defendant is unable, tracking that language. Then it says on the issue of insanity, it is the defendant who must prove his insanity by clear and convincing evidence. Clear and convincing evidence is evidence sufficient to persuade you that the defendant's claim is highly probable. It is a higher standard of proof than a preponderance of the evidence, but less exacting than proof beyond a reasonable doubt. A preponderance of the evidence is enough evidence to persuade you that the defendant's claim is more likely true than not true. If the defendant proves insanity by clear and convincing evidence, then you must find the defendant not guilty only by reason of insanity. And so we are asking for a similar instruction. At a bare minimum, we are asking for the court to provide some kind of language that distinguishes between the two, as they do in civil cases when presented with a situation where the jury has to consider two different burdens. So that is what we're asking for in order for it to be more clear to the jurors that one burden is higher than the other burden. If the state has a problem with the specific language, I'm not dead set on the language I proposed in my motion necessarily, but we are requesting that that the jury be instructed that there is in fact a difference, they're not the same. I believe that's it.
Response?
And Judge, you want this back?
No, I got it.
For the record, the payroll case is 177 Southern 3rd 32, second DCA case from 2015. It was an insanity murder case. One of the issues the defendant was claiming, because the language in the two instructions is similar, the jury was unable to distinguish between the two standards of proof, but read together. The court disagreed. That's one of the arguments the defense has. So the court disagreed in the Second District Court of Appeal. They also said that the definition clear and convincing used in the standard insanity instruction has been used in Florida for over 30 years. And they cite the exact same jury instruction in their case that was will be used in this particular case. We've had over 30 years of law. The second DCA in 2015 in the insanity murder case decided this is the appropriate thing to do. I'd ask this court not to change the standard jury instruction that has been reviewed and approved by the second DCA as well as the Florida Supreme Court. And I think that we start adding more to it, preponderance of evidence, we start adding more levels that could potentially cause confusion. The standard jury instruction is appropriate as it is. It has been reviewed by the second DCA in 2015 in the insanity murder case. It should not be changed, and we're asking the court not to change it. We've been living with this law for 30 years.
Why do you think this wasn't an appellate issue?
Because they specifically say that they raise it on appeal. There's no language regarding them ever making that request.
Yeah, but they don't distinguish between it wasn't made below, so it's got to be fundamental error. There's something about that.
Well, normally, just when they track the history of the case, if it was raised, they would have said the defense had requested this instruction, it was denied. And so just, from the language that we normally see in cases, it specifically says that He appeals his conviction following the jury trial on appeal, challenges the standard jury instruction. There's no indication that they had raised it initially.
No,
I don't mind doing some more research and looking into it. I can try to find the trial.
No, that's, I mean, I think that's a leap to say that it was first raised on appeal and wasn't preserved from the lower court. I'm going to deny the defense's request. This case, PWO, obviously stands for the proposition that that instruction has been approved and affirmed by the Supreme Court, that that's the instruction that is sufficient. Additionally, it talks about the prosecutor didn't argue in that case that it was any different than clear and convincing and didn't draw any similarity between the language of beyond a reasonable doubt. I'm sure that's not going to happen here. I don't disagree with you, but I'm not making, on the committee making the jury instructions, I don't disagree with you that it's a pretty evidence precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter and issue. I don't necessarily disagree with you that sounds like it might be the same instruction worded in another way, although I think you can argue that to the jury and clearly define the difference to them, which I'm sure you will. And it would certainly be improper for the state to suggest it's anything other than a lower burden, which I'm sure they wouldn't do. So that's my ruling, and I can't imagine what else you could find that would convince me otherwise. Okay.
Your Honor, we're requesting 3.6C.
Okay.
Excuse me, as well as a second tablet medication.
3.6C. Okay, I already read it, but I'll read it again.
Yeah, I would like it to be.
Okay,
We would
any
like
objection to that?
I thought it was 2.1D.
3.6C.
3.6C.
Second tablet medicine.
No objection to that, right? Okay. So I think I know what to do. Do you have any questions? Okay. Anything else we need to cover? The draft will be ready by 9 in the morning, maybe 10 in the morning, Monday.
Sure.
Okay. Which one?
I'll be here all day Sunday, so.
No,
it doesn't
you
matter.
won't be.
That's okay.
So 9 or 10, which is better?
Well, I'm here 7:30, so.
Okay.
10.
10. So it'll be ready at 10. And then I think you need to really carefully read them more than usual because they're going to be printed up.
Right. Can I ask if she got the
Yeah, the-
rest of felony murder?
Yeah, felony murder, 7.3, and ag child abuse for the underlying 16.1.
Yeah. Judge, we may need to address ag child abuse,
Yeah.
narrow down what we need in that.
Yeah, let's do that.
16.
Well, it says that's 16.1, Judge.
Yeah, okay. Committed aggravated battery, willfully tortured, maliciously punished. What would you suggest, Mr. Ellis?
That's it, A.
I don't think A.
A and E, Judge?
I think definitely E.
I think
I think,
What about E?
I think,
I'm not inclined to get A.
I think E, yes. I think if we're not going to do A, I think E's the only one that applies.
Agree?
I mean, I don't think aggravated child abuse applies at all, but I think if it
What I'm
applies at
gonna
all,
do-
it would be E.
I got it, okay, E.
Judge, we need to go all the way back to say we're objecting to felony murder instruction being given.
Yeah, correct,
Got
sorry.
I understand. I think E fits. You know, the only thing somebody could say, though, is that it caused death, not great bodily harm.
Well, that's what makes it the felony murder.
I understand.
There is, of course.
Okay, never mind. Stupid question.
I think we don't need deadly weapon if we're not doing, I mean, that doesn't apply anyway.
No.
And then there's a definition for maliciously, if we're doing E. I don't see that in E.
Willfully, you mean? Oh, or maliciously also?
I'm thinking maliciously doesn't, you don't need maliciously.
Oh, I see what you're saying. Leave willfully and no
Yes.
maliciously?
Yep.
Right.
Gotcha.
Okay, then what about 1E is alleged, so then we have to give the definition
For
child abuse means.
Right.
Right.
Okay. The intentional infliction of physical or mental injury upon a child. Okay, an intentional act that could be reasonably. Or, do you want an or and just the one in the intentional infliction or act? Or?
Intentional infliction of physical or, an intentional infliction of physical injury upon a child or an intentional act?
Yes.
Yes.
Yes. Defense, you object?
Yes, we do.
Just because you object to the felony?
Correct, but
Okay.
I would agree that it makes no sense like that.
The
And
act-
taking out the third parenthesis.
Oh, yeah.
Right.
Yeah.
Mental, there's no mental injury, right?
And there's no evidence of that for ag child.
It's not a crime. I mean, that doesn't apply.
Right,
Physical
right.
discipline.
I think the rest of it doesn't apply.
Okay, agree, defense, all of it's out.
Sorry, let me just scan real quick. Oh, right, yeah.
Okay. Anything else that's gonna be,
Can I just ask before why ag child abuse A doesn't apply? I know there's no weapon.
ag bat, you mean?
I'm sorry, ag bat. What did I say? Ag child abuse?
Yeah.
Ag bat. Because
Um,
if it's an intentional act, or number one, intentionally cause bodily harm, and two, and so doing cause great bodily harm, permanent disability, permanent disfigurement. There's no weapon, but I think the great bodily harm and intentional act would apply.
murder, gesture struck, cause bodily harm. So all you're asking for is 2A for aggravated battery?
Well, in part one, I think we're asking for A and E.
Right, but then
Right.
it says, give us applicable. So that's all you're asking for is just that.
I think it would be number one, defendant intentionally,
Touched or struck, caused bodily harm.
I think B, caused bodily harm, and then 2A, and then so doing cause great bodily harm or permanent disability or permanent disfigurement.
Makes sense to me, although I said I wasn't gonna do it, so why shouldn't I do it?
So, the statement's true to find one intentionally, you're saying A or B for one?
B?
And then
And
2A.
then two,
It seems like saying, one, defendant intentionally, B, caused bodily harm to victim, and then to say, in doing so, defendant intentionally or knowingly caused great bodily harm seems weird.
Yeah, that does seem a little.
Like, it seems like it's supposed to be either you touch or strike and intend the great bodily harm, or you cause harm with the deadly weapon.
But it's not a deadly weapon.
Right, that's what I'm saying, like, it doesn't seem to make sense if it's the 1B and 2B.
Well, I think
Or 1B and 2B.
it's saying cause bodily
Well, what
harm.
about, do I have to do 1A or B? Couldn't I just say 1A and then say in so doing?
But there's no touching or stroking against the will.
Yeah, I think it has to be B and then A. I mean, B is saying cause bodily harm. And then A is basically what makes it the ag bad, right? Great bodily harm, permanent disability, or permanent
Yeah,
disability.
well, I think it's, I don't disagree that, I don't know how to fix it though, because that's an element of battery.
Well,
Intentionally cause bodily harm. Okay, what about intentionally cause great bodily harm? Permanent, are you asking for permanent disability?
I think just great bodily harm, Judge.
Okay, so couldn't we just, in order to prove blah, 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 defendant intentionally or knowingly cause great bodily harm, period?
That
no,
doesn't
that
establish the elements.
takes
of
away the
aggravated.
elements of the ag bad.
Yeah, I would be more comfortable just tracking what the instructions.
Okay, I'll just do that.
And if we're taking out permanent disability, permanent disfigurement, we can take that out of letter E as well. If that's agreed.
Okay,
I don't think that if we say to prove aggravated, he intentionally caused bodily harm and then caused great bodily harm, that doesn't meet the elements of aggravated battery. Because there's no touching or striking. So I think it's touch or strike and cause great bodily harm, or cause bodily harm by the use of the weapon or whatever, you know.
If you look at the ag bad instruction, 8.4, it says to prove the crime of aggravated battery, state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery: intentionally touch or strike against his will, intentionally cause bodily harm to the victim. That means either or. That's just a definition of battery. And then it's the same, number 2, committing the battery, intentionally cause great bodily harm. So I think number 1, A or B is just a definition.
I can give both A and B, A or B.
For 8.4, it's you intentionally touch or struck, and part 2, cause the great bodily harm or disfigurement, or if you intentionally cause bodily harm, you used a deadly weapon. That's how you get to aggravated battery. I don't know that, you wouldn't say on 8.4, number 1, the defendant intentionally caused bodily harm to victim, and then drop down to 2 and use A and say in committing to battery, you knowingly or intentionally cause great bodily harm.
Well, I can do both. I can do touch or struck against the will of the victim, and
Except that there's no evidence of that.
of what, touch or struck?
Right.
That's true. So, cause bodily harm.
I think we're back to that, Judge.
I think so too.
So we're back to saying defendant caused bodily harm and in the course of committing the battery intentionally or knowingly caused great bodily harm. That
Yes.
does not meet the elements of aggravated battery.
Well, that's good for you then, right?
I don't know
I guess so.
what.
Let's go for it.
Huh?
I guess it is.
It's
That's
aggravated
good for
child
you.
abuse, not aggravated battery.
Huh?
Because we're talking about aggravated child abuse, not aggravated battery.
Right, but 1A is an aggravated battery.
I don't
Committed
know,
and aggravated, that's the whole
And
thing.
these are the
is-
suggested definitions of it.
but I don't know why it wouldn't apply. I mean,
Well,
it's
they're saying that it's a bad, it's a bad instruction, so if he gets convicted of aggravated child abuse, well, we're not gonna know which one it was.
I just don't know why it wouldn't apply, because if it's an intentional act and you intentionally cause bodily harm to someone else.
Yeah, what's the flaw in saying, I mean, if you don't wanna say, I guess you don't wanna say. I don't understand it either, but, I mean, what they're saying, that it doesn't define the crime, I think it does.
Well, 1A just says, I mean, going back to aggravated child abuse, to prove aggravated child abuse, 1A is committed an aggravated battery. And so then we go to read the instruction on aggravated battery. And the way that the state's proposing is not the instruction on aggravated battery.
But you go to what's in aggravated child abuse to determine aggravated battery, not the aggravated battery instruction.
I mean,
Well, here it said, I mean, to prove aggravated battery was committed, the state must prove the following.
Intentionally touched or struck, did that, and caused great bodily harm, did that.
How? Where's the touch or strike?
He picked her up, dropped her, and that's a touch, you got to physically touch her to do that.
Yeah,
If I throw you out a 5-story built window, that's touch or strike.
okay. Maybe it's just that simple.
we're objecting, so if they want it like that, I mean,
All right,
we're
I'll do it
certainly
like that,
objecting.
that's what you want.
Are we giving just A or A and B for number one?
Well, they're saying shouldn't give A or B and should just give B, and Mr. Ellis is saying do both, and I'll do both. I don't know if you throw me out of a 5-story window if that's aggravated.
This goes
battery. Do you want to leave that till Monday morning?
Yeah, we can leave it for Monday morning.
Okay.
Judge, we need to go over 3.9.
The lessers, is that lessers?
No, weighing the evidence.
Oh. Oh, okay.
There may be things that don't need to be talked about, like accomplices and informants, child witness, those kind of things.
Okay, Angie will figure that, but that's.
And 7 and 10 probably don't, and the numbers don't need to be.
Right, I know. I don't think,
What?
I don't think.
No pressure on any witnesses, 7.
Yeah,
And
6,
no
7.
genuine reputation on 10.
Right, so there's no 6, there's no 7, there's no.
Well, there is 6 because all the experts got money.
Oh, okay. 6, no 7, there's obviously an 8, and there's no 9 and 10, right?
What number are we on? I'm sorry.
We're on 3.9
3.9
range
weighing
evidence.
And I guess 9's out as well, Judge.
Yep. Mr. Jonchuck didn't testify, blah, blah, blah. Okay.
The defense needs to probably let us know what paragraph they would request on not testifying, or both.
Both.
What about defendant's statements? Do you want that in
Yes.
that? You do?
Yes.
Okay. And then do you want both paragraphs of not testifying, the Constitution and the other one? Okay.
Yes.
Should we put, never mind, it's too flip. Well, I'll say it anyway. We could put some, something in there on number 4, remember the lawyers are not on trial, their appearance. Okay, anything else we need to deal with?
One thing I can, Judge, there is one thing, and it's going to be, and I don't have a proposed instruction at this point. The insanity jury instruction says it is a defense to the crime, and obviously we have a lot of crimes here, so I'm going to try to work on that to make sure that the jury understands. Insanity applies to all these things, not just first-degree murder. Insanity is an offense to aggravated child abuse as well.
I guess, I think that's pretty clear.
That's already included in the first degree murder.
I mean, the questions that we've gotten throughout the week, I don't know that there's anything that can be too clear.
Now we're disparaging the jury.
No, everyone's disparaging the jury, but calm down.
I'll be here on Sunday, I'll propose.
So draw it up, I
don't have it
Okay.
right now, I can't figure it out, but.
My understanding is that would be for multiple charged crimes.
And I would agree, and that's our objection to allowing murder to be proved in 2 separate ways, and that's what brings it all in is when, and I'm not suggesting that the states, that the case law says they can't do what they're doing. I'm suggesting that when they do it that way, we then have to try to figure out how to minimize the damage to Mr. Jonchuck, making sure they understand insanity applies to everything.
Okay. Anything else? Done?
Nudge it. All rise. Adjourned for the day.